Dubai had led also the innovation in the Dubai courts for a long time. They innovate a lot of systems in the Dubai court, and one of these systems is the case management. I want to ask the lady from India, because she spoke about also the case management. The case managers, are they judges, are they capable also to handle these kind of cases? Do they interfere to settle the disputes between the parties or not? Thank you.
Good morning, sir. The judges do not interfere with the case management system. Where the judge's role is if a dispute is brought before them and they see there is a scope of a settlement or a resolution without getting into trial, there are specialized high courts in our country like the Delhi High Court and the Bombay High Court, with which we have the mediation centers associated with it. The judges may refer the matter to the mediation cell to see and ensure if an experienced mediator can get and resolve a dispute. If not, within a particular time frame, the matter would be brought back before the court. With respect to the second aspect of your question in relation to, if I am not mistaken, about the capital bit, but nowadays the courts are investing in this aspect to ensure that technology and digitalization is brought in the system so that we can have less amount of disputes pending before the courts and ensuring speedy and efficient justice delivery system in our country. But it's a new system. The implementation is yet to be seen. It's just 1.5 years where we have this new case management system introduced in our country, and in a legislative manner it has been introduced. So I would say it would take at least 3 to 4 years to see the actual impact and how it is being translated in reality. Thank you.
Thank you for the presentations. I have a question for Ms. Owais. What's the difference between the decisions of DIFC courts and awards granted by DIFC Arbitration Center, and particularly the differences of enforceability of the decisions by the court and awards by the arbitration center? Thank you.
First of all, we are a court like any other court, so we issue judgments by the judges who are appointed by decree by the ruler of Dubai. Arbitration awards are, of course, binding, as the UAE is part of the New York Convention as a signatory. And the relation between us and the DIFC LCIA Arbitration Center is we all fall under the Dispute Resolution Authority, and we are the curial court for the DIFC LCIA Arbitration Center. So when there's a final award to be ratified for enforcement, it will come to the DIFC courts because we take care of all of their arbitrations when it comes to enforcement. And of course, if there were any disputes within the course of the arbitration, they will come to us as the administrative courts if there were like disputes within the handling of the arbitration matter, whether, tribunal members and what have you. And generally speaking, our judgments in the DIFC courts are enforceable throughout the UAE. And of course abroad, and there are like specific mechanisms that parties can do, whether by judicial deputization or by sending the judgment to other countries if the assets are abroad. So does this answer your question? Thank you. And I want to actually just add, in terms of the courts in the UAE, the court system is a federal court system, and we have, of course, local courts within specific emirates, as the constitution allowed for, specific emirates, if they wanted to have their own local system, they can do that. So we have Dubai, Abu Dhabi, and Ras Al Khaimah having their own local system, where we then were established by the ruler of Dubai as the Dubai International Financial Center to cater for specific types of disputes. So in Dubai now you have a forum of choice, you have courts operating an Arabic civil system, and you have the English common law courts operating in the DIFC. Thank you.
Well, in India, with regard to the innovation brought through the timelines for filing. If a party fails to comply with the time set for filing, what happened? Are there any procedural requirement to deal with that?
If I'm not mistaken, your question is, are there any kind of penalties or any kind of impositions on the parties?
Absolutely.
Yeah. So as I mentioned, there has been an amendment to our Code of Civil Procedure, which requires you to make the filings within the timelines that have been provided, like a 120-day period, 60 days, 90 days. In the event that does not happen, it takes away the right of the party to make those submissions, and the matter will proceed as if no pleadings have been made by the other side. It's based on that. One aspect is that, and the other aspect is if you can explain the reason for the delay and you're actually asking for a condonation, now we actually have the cost imposed, which has been taken very seriously. It's been years where cost was something which was just there on paper and it was hardly imposed on the parties. As a result, there was no kind of threat or any kind of fear that if I miss a deadline, they knew that they could just come and again ask for an adjournment or for any kind of excuse. But nowadays, unless it's a very valid reason, the parties will not, their right to make any kind of submissions will be foreclosed, and if allowed, there will be cost imposed on the parties.
Pierre, nice presentation. Just to piggyback on the question he asked, quick comment and question. The first issue is it possible that in your reforms in India you also consider imposing penalties on counsel? Because I recall one of your statements was a strong attempt to do away with unnecessary adjournments. And there's this possibility that parties and counsel become so used to the so-called penalties that are there to the extent that it really doesn't matter anymore. They become jaded, more or less. So from my jurisdiction in Nigeria, the federal high courts, portions of the rules, at certain occasions imposes those costs on counsel to make them responsible for the delays that may have been occasioned in the matters they're handling. So perhaps this is one way, and I would also suggest, because I see some similarities with your presentation with what I go through back home, that there must be constant review, and you must find a way to set short-term goals, because there's always that danger that when parties and counsel become used to those penalties, it becomes run-of-the-mill, and it's no longer basically an issue. The next interesting point you made was the volume of cases. Right. If I heard you correctly, you talked about 200 cases, then subsequently attempts to reduce it to 50.
Right.
And I wonder, I've always taken the view from a reform point of view that courts, particularly in developing economies like ours, should have managers or administrators different from the chief judge or the chief registrar. Because in my jurisdiction, you have situations where you are instructed to file a suit, and you typically cannot tell your client that this will be done within 1 week, 2 weeks. So you go through the process of preparing the processes, you submit it to the registry, and it takes forever. Then you get information to the effect that the chief judge is out of town. He's gone for a conference. Maybe he's at a litigation forum conference. And for that reason, your case is not assigned until he gets back. But if you have a court manager, someone who's probably has some managerial skill or experience, background, that I think would run smoothly. I think there should be an attempt to take away assignment of court cases from judicial officers and put it as a responsibility for non-judicial officers who work within the judicial justice system. Thank you.
Sir, as a first point which you mentioned about whether penalizing the lawyers itself, I'll share an example with you. Last year, one of the Supreme Court judges, there's always a tendency, if the senior can't make it on time, they'll send the junior counsel to just appear and ask for an adjournment. So one of the cases which was highly reported by in India was one of the Supreme Court judges told this junior counsel, so what if your senior is not here? You are well prepared, why don't you go ahead? There was no cost imposed on it, but I think one good takeaway from that incident was, it was in a way ensuring that the seniors take the Supreme Court seriously. Second is you're giving the opportunity for the young lawyers to come up and ensuring they get the opportunity of arguing before the Supreme Court, because litigation in India, in certain courts specifically, is still very old tradition where it's not the junior lawyers who get to argue the matter. It's a traditional system where only the senior counsel is going to appear and he's going to make the submissions. So I would think that example is a solution for both ways, ensuring that your presence is there. Otherwise, it's a huge reputational loss. And secondly, it's giving the opportunity to the junior as well to come up and argue the matter. On the second aspect, in relation to appointing a case manager, this is something which we are seeing more when it comes to the institutional arbitrations in our country, but are yet to be seen when it comes to the court specifically. We do have the court registry itself, which manages the matter, but as you rightly said, the judge is on leave. These are things which are still not done away with within the system, and it's only on that day or maybe a day before that you would get to know. In the Bombay High Court at times, because of this entire e-court project being set up, what happens is if your law firm or the lawyer is registered with the particular High Court, you get an email one day before the hearing itself that this is your matter, this is where it is listed. But it's still not come to the position or a place where you will be informed in advance that the matter is not going to be taken up unless the other party is equally vigilant and is kind enough to inform the other party that yes, we are not going to go ahead with the hearing. So as I mentioned, it's still a long way to go for all of us, and it's a role which is to be played by all parties involved in the litigation scenario.
Thank you. Just to add to the comment that was made with regards to how case management is done in Nigeria, I know too well that in Lagos, the Lagos State High Court has a process. You have the admin judge who takes responsibility for assignment of cases to court, and you have the chief judge of the state. So you have a separation in terms of assignment of cases and management of cases. Then you have the core judicial function of the CJ. Now, in the case management is about administration of the court system, and it's both ways. And since we have a leave from Lagos, and what Lagos is doing in that direction is to separate both functions, other jurisdictions are beginning to copy from what Lagos is doing. And if we take that back to the case management you talked about as well, if you have separation, then I think the system will be more efficient. Thank you very much, ladies and gentlemen. We've come to the end of this section. We hope we've been able to meet the expectation of this section. Thank you very much for your attention.